Good day. This is Police Lieutenant Colonel Ax Daliba, your Panyerong Police. Today, we will be discussing Republic Act number 10175 or the Cybercrime Prevention Act of 2012 and some related issuances. So what is the scope of our presentation? We will be discussing the Budapest Convention on Cybercrime, salient provisions of Republic Act number 10175, and some related laws and issuances. So what is the Budapest Convention on Cybercrime? Effective July 1, 2004, it is the first international treaty on crimes committed via the Internet and other computer networks. It provides the mechanisms to address cybercrimes by facilitating their detection, investigation, and prosecution, both on domestic and international levels, providing arrangements for international cooperation. The convention was signed by the then President Rodrigo Roa Duterte on December 9, 2016, and was ratified by the Philippine Senate on February 19, 2018. The convention has a total of 67 country signatories so far, and the date of entry into force in the Philippines is on July 1, 2018. We now go to Republic Act number 10175 or the Cybercrime Prevention Act of 2012. This law was approved on September 12, 2012. It took effect on October 3, 2012. However, in relation to the case of Decini versus the Secretary of Justice, a temporary restraining order was issued on October 9, 2012. Subsequently, the TRO was lifted on February 18, 2014. Pursuant to the law, its implementing rules and regulations was approved on August 12, 2015. Republic Act 10175 provides substantive law on cybercrime and procedures on the search, seizure, and examination of digital evidence. Before discussing the law, let's go first to some definition of terms. Cyber. The word cyber refers to a computer or computer network, electronic medium in which online communication takes place. How about cybersecurity? Cybersecurity refers to the collection of tools, policies, risk management approaches, actions, training, best practices, assurance, and technologies that can be used to protect the cyber environment and organization and users' assets. A computer data, on the other hand, refers to, number one, any representation of facts, information, or concepts in a form suitable for processing in a computer system. It includes a program suitable to cause a computer system to perform a function. And number two, it includes electronic documents or electronic data messages, whether stored in local computer systems or online. A malware, on the other hand, is any malicious software designed to harm a computer system, while ransomware is a type of malware that encrypts data and demands a ransom for its decryption. Service provider, you will be encountering this word frequently. A service provider refers to, number one, any public or private entity that provides to users of its service the ability to communicate by means of a computer system. And number two, it refers to any other entity that processes or stores computer data on behalf of such communication service or users of such service. So, what's the difference between cybercrime and cyber-enabled crimes? Cybercrimes are sophisticated attacks against computer networks, hardware, and software. These are likewise referred to as high-tech crimes. Cyber-enabled crimes, on the other hand, are those traditional crimes that are facilitated and amplified by the Internet or through the use of information and communications technology softwares or hardwares. For example, sexual abuse of children, financial crimes, and even terrorism, when committed through ICT, is considered cyber-enabled crimes. So, what are the cybercrime offenses under RA 10175? There are three. These are, number one, offenses where the computer is a target. These are offenses against the confidentiality, integrity, and availability of computer data and systems. Number two, offenses where the content itself is criminal, or what we call content-related offenses. And number three, offenses where the computer is a tool in committing a crime, or what we call computer-related offenses. What are the offenses where the computer is a target? These are illegal access, illegal interception, data interference, system interference, misuse of device, and cyber squatting. What is illegal access? Illegal access is access to the whole or any part of a computer system or application without right. This is typically what we consider a type of hacking. How about illegal interception? Illegal interception is one that is made by technical means without right of any non-public transmission of computer data to, from, or within a computer system, including electromagnetic emissions from a computer system carrying such computer data. This is when your cell phone or your computer is being listened to or intercepted without authority. We now go to data interference. Data interference is the intentional or reckless alteration, damaging, deletion, or deterioration of computer data, electronic document, or electronic data messages without right, including the introduction or transmission of viruses. An example is when a person opens your cell phone, then alters or deletes your pictures without your permission. How about system interference? System interference is the intentional alteration or reckless hindering or interference with the functioning of a computer or computer network by inputting, transmitting, damaging, deleting, deteriorating, altering, or suppressing computer data or program, electronic document, or electronic data messages without right or authority, including the introduction of transmission of viruses. This is when a signal jammer is being used, or when an equipment we call IMSI catcher is being used to send out SMS to your cell phones. How about misuse of device? Misuse of device is the use, production, sale, procurement, importation, distribution, or otherwise making available without right. Number one, a device including a computer program designed or adapted for the purpose of committing any of the offenses under RA 10175. Number two, a computer password, access code, or similar data by which the whole or any part of a computer system is capable of being accessed with intent that it be used for the purpose of committing any of the offenses under this law. Number three, possession of an item referred to in number 1 and number 2 above, with the intent to use said devices for the purpose of committing any of the offenses under this section. The gist of this offense is the intent to use such devices for violating the law. How about cyber squatting? It is the acquisition of domain name over the internet in bad faith to profit, mislead, destroy reputation, and deprive others from registering the same if such domain name is, number 1, similar, identical, or confusingly similar to an existing trademark registered with the appropriate government agency at the time of the domain registration. Number 2, identical or in any way similar with the name of a person other than the registrant, in case of personal name. And number 3, acquired without right or with intellectual property interest in it. What about Republic Act 10173 or the Data Privacy Act of 2012 in connection to RA 10175? We must take note that Section 29 of RA 10173 penalizes unauthorized access or intentional breach. It is imposed on persons who knowingly and unlawfully violate data confidentiality and security data systems, break in any way into any system where personal and sensitive personal information is stored. While Section 30 of Republic Act 10173, on the other hand, penalizes the concealment of security breaches involving sensitive personal information. It is imposed on persons who, after knowledge of a security breach and of the obligation to notify the National Privacy Commission required by law, intentionally or by omission, conceals the fact of such security breach. So, what are the other types of cybercrimes? Other types of cybercrimes are computer-related offenses. These are, number 1, computer-related forgery. Number 2, computer-related fraud. And number 3, computer-related identity theft. So, we go to the first one. What is computer-related forgery? It is the unauthorized input, alteration, or deletion of computer data resulting in inauthentic data with the intent that it be considered or acted upon for legal purposes as if it were authentic, regardless whether or not the data is directly readable or intelligible, or the act of knowingly using computer data which is the product of computer-related forgery as defined herein, for the purpose of perpetuating fraudulent or dishonest design. It is essentially forgery, but using ICT as a means to perpetrate it. How about computer-related fraud? Computer-related fraud is the unauthorized input, alteration, or deletion of computer data or program or interference in the functioning of a computer system, causing damage thereby with fraudulent intent. The gist of this offense is the fraudulent intent. So we go to computer-related fraud such as phishing, vishing, and smishing. What are these? Phishing is the sending of an email or a website link for users to click on, which might either download malware onto the user's devices or send users to a malicious website that is designed to steal their credentials. Vishing is a type of phishing using the voice. So it is via telecommunications. And smishing is a type of smishing via text messaging or SMS. Another one under computer-related offense is computer-related identity theft. It is the intentional acquisition, use, misuse, transfer, possession, alteration, or deletion of identifying information belonging to another, whether natural or juridical, without right. Another type of cybercrime are content-related offenses. Under these are number 1, cybersex, number 2, child pornography, and number 3, libel. Cybersex and child pornography were already repealed by Republic Act 11930 or the Online Sexual Abuse of or Exploitation of Children or the OSAIC law. We now discuss libel under RA 10175. It is the unlawful or prohibited acts of libel as defined in Article 355 of the Revised Penal Code, committed through a computer system or any other similar means which may be devised in the future. Take note that this is with respect to the original author of the post only, and does not include those who simply receive the post and react to it. So what are the elements of libel under RA 10175? So these are defamatory imputation which causes dishonor or discredit. Number 2, malice, either in law or in fact. Number 3, publication or the posting. Number 4, the victim must be identifiable. Number 5, the suspect must likewise be identified. And number 6, it must be committed through information and communications technologies. So where is the venue for filing? The place where the complainant actually resides at the time of the commission of the offense. What is now the prescriptive period of online libel? In the case of Kausing versus People, GR number 258524 on October 11, 2023, the prescriptive period of online libel is 1 year. We now ask, is a certificate to file action required for online libel cases? The answer is no. Not covered under Administrative Circular number 1493. And of course, offenses for which the law prescribes a maximum penalty of imprisonment exceeding 1 year or a fine over 5,000 pesos. Let's move on to other offenses under RA 10175. What is aiding and abetting in the commission of cybercrime? There is aiding and abetting when a person who willfully abets or aids in the commission of any of the offenses enumerated in this act. The other one is attempt in the commission of cybercrime. Any person who willfully attempts to commit any of the offenses enumerated in this act shall be held liable. Take note, under Section 6 of RA 10175, all crimes defined and penalized by the Revised Penal Code and special laws, if committed by, through, and with the use of information and communication technologies, shall be governed by the relevant laws and covered by the relevant provisions of this Act. So, what are the liabilities under other laws? Please be advised that a prosecution under RA 10175 shall be without prejudice to any liability for violations of any provision of the RPC or special laws. Which means, for example, that for a single act, the offender can be charged for as many violations penalized by various laws, except for the following: online libel, as to which charging the offender under both Section 4, Paragraph C, Number 4 of RA 10175 and at the same time Article 355 of the Revised Penal Code constitutes a violation of the prescription against double jeopardy. Number 2, child pornography committed online, as to which charging the offender under Section 4, Paragraph C, Number 2 of RA 10175 and RA 9775 or the Anti-Child Pornography Act of 2009 also constitutes a violation of the prescription against double jeopardy. Are SIM cards with GCash and Maya accounts considered access devices? The answer is yes. SIM cards with GCash and Maya accounts are considered access devices as defined under Republic Act number 8484 as amended, which means that any card, plate, code, account number, electronic serial number, personal identification number, or other telecommunications service, equipment, or instrumental identifier, or other means of account access that can be used to obtain money, goods, services, or any other thing of value, or to initiate a transfer of funds, other than transfer originated solely by paper instrument. We now discuss disclosure of computer data. Law enforcement authorities, upon securing a warrant, shall issue an order requiring any person or service provider to disclose or submit subscribers' information, traffic data, or relevant data in his or its possession or control within 72 hours from receipt thereof. It must be in relation to a valid complaint officially docketed and assigned for investigation. Why? Because disclosure is necessary and relevant for the purpose of investigation and subsequent filing of a criminal complaint in case. We discuss off-site and on-site principles. What is off-site and what is on-site search? Off-site search refers to the process whereby law enforcement authorities, by virtue of a warrant to search, seize, and examine computer data, are allowed to bring the computer system outside the place to be searched in order to conduct forensic examination of the computer data subject of the warrant. How about on-site search? On-site search refers to the process whereby law enforcement authorities, by virtue again of a warrant to search, seize, and examine computer data, obtains the computer data subject thereof for forensic examination without the need of bringing the related computer devices and or parts of the computer system outside the place to be searched. How about custody of computer data? When examining computer data under a proper warrant, the data must be deposited within the court or with the court. The law enforcement authority must file an affidavit certifying that duplicates or copies of the data have been made. If copies have been made, the affidavit must also confirm that all such duplicates are included in the package deposited with the court. The package deposited with the court must remain sealed. It cannot be opened, its contents revealed, or used as evidence unless authorized by a court order. This ensures the integrity of the data until the court grants permission for its use. It's also crucial to address the penalty for obstructing the apprehension and prosecution of criminal offenders. Take note that any interference with the lawful examination and handling of data could result in legal penalties, ensuring that justice is served. How about destruction of computer data? Upon the expiration of the period, whether preservation or examination period, service providers and law enforcement authorities, as the case may be, shall immediately and completely destroy the computer data subject of the preservation or the examination. Please take note of this. Under Section 18 of RA 10175, any evidence procured without a valid warrant or beyond the authority of the same shall be inadmissible for any proceeding before any court or tribunal. What is the jurisdiction of the courts for cybercrime violations? Regional trial courts are designated as special cybercrime courts. Jurisdiction applies to any violation committed by a Filipino national regardless of the location of the offense. Jurisdiction shall lie if, letter A, any element of the offense was committed within the Philippines. Letter B, the offense was committed using a computer system wholly or partly situated in the country. And letter C, the offense caused damage to a natural or juridical person who at the time the offense was committed was in the Philippines. Who are the law enforcement authorities under RA 10175? The National Bureau of Investigation and the Philippine National Police are responsible for the efficient and effective law enforcement of the provisions of this Act. Both the PNP and the NBI shall organize cybercrime units or cybercrime centers staffed with special investigators to exclusively handle cases involving violations of this Act. Can operating units within the PNP and NBI, aside from their designated cybercrime units, handle cybercrime-related cases? The answer is yes. The term exclusive does not grant the PNP Anti-Cybercrime Group or the NBI Cybercrime Division sole authority or competence to investigate violations of RA 10175. Rather, exclusivity refers to the types of cases they are specifically mandated to handle. So in summary, while cybercrimes fall under the jurisdiction of the PNP ACG and NBI CCD, other cyber-related offenses may be investigated by other appropriate units within the PNP and the NBI. This is pursuant to the DOJ OOC Advisory Opinion Number 1, dated July 6, 2018. Thank you. This is your Panyerang Police at your service.